Greetings, this is Christine Van Pelt, State Coordinator for the Indiana Assembly. This is for Gen Ed Wednesday, continuing with Brent Allen Winters, Declaration of 76, United States Constitution, a common lawyer comments, clause by clause. All right. Section 9, Clause 1. The migration or importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by the Congress prior to the year 1808, but a tax or duty may be imposed on such importation not exceeding $10 for each person. Comment. Only here and at Amendment 7 does the Constitution refer the dollar. Its value is not defined because its value is fixed and well known. As such, it is unconstitutional to alter this fixed value, as the Federal Reserve Bank chairman now does, without amending our Constitution. This clause refers to the slave trade, slavers and slave dealers, as well as some slave holders. Wanted to keep Congress from stopping anyone from bringing slaves into the country before the year 1808. The year Congress did ban the importation of slaves. Section 9, Clause 2. The privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it. Comment. The writ of habeas corpus is our great weapon against false jailing, available only in common law countries. Called the Great Writ, the writ of habeas corpus grants no right. The right against false jailing is as old as the laws of nature, but instead provides a ready tool whereby one can quickly remedy a false imprisonment. Even Scotland, though part of the United Kingdom, yet being under civil law forms, does not enjoy this writ's power. Habeas corpus is a writ court order commanding officials and jailers, indeed anyone government or non-government, holding captive another to bring that person, body, corpus, into court and convince the court that the prisoner is lawfully jailed. If that jailing power gives no lawful reason, the judge must order the prisoner freed on the spot. The common law tradition holds this writ to be the first and greatest weapon for the personal freedom, the common law having upheld it for ages before Parliament by statute confirmed it. The writ of habeas corpus, by which the authority under which a person may be detained can be challenged, is of immemorial antiquity. After a checkered career in which it was involved in the struggles between the common law courts and the courts of chancery and the Star Chamber, as well as in the conflicts between Parliament and the Crown, the protection of the writ was firmly written into English law. Right, subsection 53. Note, the Star Chamber and Chancery were both civil law tribunals. Parliament abolished the Star Chamber Court. The Chancery Courts, also called equity courts, persisted into America, but common law principles such as stare decisis, case precedent, now govern Chancery. The jury, however, are not used. Because the power of the habeas corpus writ to keep a country free is immeasurable, it alone is called the Great Writ. Rooted in olden times, to understand it requires recourse to the common law. From the earliest history of the common law, if a person was imprisoned, no matter by what authority, he had a right to the writ of habeas corpus to bring his case before the king's bench, and if no specific offense was charged against him in the warrant of commitment, he was entitled to be forthwith discharged, and if an offense was charged which was bailable, the court was bound to set him at liberty on bail. If nevertheless confirmed no new right, but only secured a right already existing. For although the right could not justly be denied, there was often no effectual remedy against its violation. Justice Taney in Ex parte Merriman 17 F Case 144, 1861. Indeed, the right of habeas corpus applies to all, regardless of standing, whether freeman, slave, or stranger. See example Exodus 22:21, Deuteronomy 1:16. The Great Writ's modern use first came to light during the Civil Canon Law Tribunal's attacks on common law freedom during the Reformation in England. Nicholas Fuller, 1543 to 1620, English Puritan Hebraist, theologian, and barrister at Gray's Inn. Though now forgotten, defended case by case in open court his clients' rights of individual conscience, advising them to remain silent for following Fuller's counsel. However, the Star Chambers and the High Commission's priest judges failed Fuller's clients for contempt. Jailed Fuller's clients for contempt. In response, Fuller appealed to the Common Law Court of the King's Bench for the writ of habeas corpus. They, Fuller's clients, ought to be released, Fuller argued, because the High Commission has not been empowered by law to fine or imprison. See generally this handbook, U.S. Constitution, Article 2, Section 1, Clause 8, and comment discussing oaths. Indispensable to the civil canon law's devices of inquisition is the power of government to hold the target of its investigation under arrest in order to wear him down, discourage him, and subdue him into conformity with the will of the state. Jailing a suspect or potential witness for long spells under hard and humiliating conditions can break his will and force his compliance to false confession or testimony. In 1679, in response to such practices of priest kingcraft and to enforce the common law right of habeas corpus, Parliament passed the Habeas Corpus Act, fixing and ensuring a sure-footed procedure for all those jailed, whereby the one jailed or a concerned party can petition the court to command the jailer to bring his prisoner before the court and convince the court that the imprisonment is lawful, i.e., satisfies the common law due process. In short, the writ burdens the jailer to prove his jailing of the petitioner is lawful. The writ of habeas corpus is applicable against not only the government, but also against anyone holding another falsely. For example, the writ can run against a parent or other family member having false custody of a child, whether by mistake, misunderstanding, or by willful intent, i.e. kidnapping. The writ can also run against a hospital for holding one without right. This safeguard against false imprisonment enables fulfillment of God's covenant to spread out and fill the earth. The Habeas Corpus Act created no new right against unlawful false imprisonment, but instead provided the wrongly jailed man a real, in-place, readily available procedural remedy, enabling enjoyment of the ancient right. Upon a jailed party's petition protesting false imprisonment, the court will issue this great writ to the jailer, commanding that he make return on the writ by bringing the prisoner's body, corpus, before the court and satisfy the court that the imprisonment is lawful. If the jailing power fails to meet this burden, the court will order release of the prisoner forthwith. If, however, the jailing power ignores the court's writ, the court will order the sheriff or its marshals or bailiffs to arrest the one refusing to make return on the court's order, and to jail that jailer for contempt until he agrees to obey the writ, called putting the jailhouse key in the prisoner's pocket. The writ commands the jailer to bring his prisoner before the court for two reasons. First, that the petitioner may testify, call witnesses, cross-examine witnesses, and make oral arguments. Second, that if the court finds that the law demands his release, he will be set free on the spot, avoiding the jailer's dallying or outright refusal. Of great note, the writ of habeas corpus requires that the jailer, whether sheriff, police chief, hospital administrator, warden, military officer, know, understand, and show good and lawful cause for the jailing of the person in question. Further, the burden is on the jailer to prove the lawfulness of his holding the one jailed. The one jailed need prove nothing or even say nothing. In short, the one jailed need prove nothing nor otherwise testify. The Habeas Corpus Act secures speedy relief from unlawful imprisonment. Perhaps, says Wright, the most important writ known to the constitutional law of England. This writ is again in the forefront as the federal government balks at recognizing Islamic prisoners a right to it. As state power multiplies, this ancient writ becomes more needed, not less. War breeds dangerous state power. War begets powerful men. Powerful men beget more war. Thus, history testifies. Indeed, wartime abuse is bringing the necessity of habeas corpus into clearer focus. To sum up, because the writ of habeas corpus strikes at Inquisition, the foundation of Roman civil law, it is unknown, indeed forbidden, in civil law states. The writ is a jailed person's weapon, enabling handy challenge not only of the illegality of his imprisonment, but also the lawlessness of the jailing power. By removing the state's power of intimidation through arbitrary jailing of an undefined length of time, the writ of habeas corpus strikes at the heart of tyranny. Only in extraordinary circumstances does our Constitution allow suspension, ignoring of the writ. Throughout our history, whether concerning slavery, war, or other matters, the writ of habeas corpus has been available and often used. Writing in 1833, Justice Story recognized that only Congress has the power to suspend habeas corpus, adding, no suspension of the writ has ever been authorized by Congress since the Constitution. See also Ex parte Merriman 17 F Case 144 1861. By placing the guarantee of habeas corpus in Article 1, the framers put its suspension in the power of Congress alone. Under our Constitution, says Justice Taney, only Congress has authority to suspend the writ of habeas corpus. As the power is given to Congress to suspend the writ of habeas corpus, wrote Justice Story, the right to judge whether the exigency had arisen must exclusively belong to that body. Chief Justice Marshall said that if suspending the writ is necessary for public safety, only Congress has such authority. Justice Taney concludes, I can add nothing to these clear and emphatic words of my great predecessor. Keeping freedom demands watchfulness. As the decades and centuries roll on, legal labels will vary and persons concerned will change. But the steady flame of ancient remedies for trespass upon God-given dignities in all men remains. Hence, common law's right to the habeas corpus writ applies to Americans and non-Americans alike. This great writ, says Tom Jefferson, secures every man here, whether alien or native free man, against everything that is not law, whatever shape it may assume, understood aright only in light of the common law. The habeas corpus clause thus applies in every geographic place the United States chooses to act. History is clear. Without this writ, freedom fails, the innocent will rot in jails. See this handbook, U.S. Declaration of 76, Section 28, and comment. To understand the meaning of the habeas corpus clause, it will be necessary to have recourse to the common law, for in no other way can we arrive at the true definition. It is justly esteemed the bulwark of personal liberty, applied in every case of legal restraint. For every restraint upon a man's liberty is, in the eyes of the law, an imprisonment, wherever may be the place or whatever may be the manner in which the restraint is effected. Justice Joseph Story. Section 9, Clause 3. No bill of attainder or ex post facto law shall be passed. Comment. A bill of attainder is a legislative act to punish a person without affording him the right to a trial by jury. An ex post facto law makes criminal an act already done that no authority had declared illegal before the act was done. Both a bill of attainder and an ex post facto law violate common law separation of powers, because both are Congress's attempt to exercise judicial powers. Both also thwart the course of the common and thus violate due process. Magna Carta Chapter 45, calling it the law of the land. See this handbook, U.S. Declaration of 76, Section 20, and comment, U.S. Constitution, Article 6. See you on the next call. In love and peace.